foundational principle of 143(1) attorney that when he talks of a question of law has a reason. These are the preconditions. A
That's
question
right.
of law or fact has a reason. That means a question of law that has not been answered in the past. Therefore, the question of law that would arise for 143(1) will be the one which has not been answered by this court first. And therefore, that question is coming first time to be answered.
Yeah.
So 143(1) jurisdiction will always be at least guided by this principle.
That's true. But therefore, 143 conditions, if you're satisfied, your lordships will go into entering into the question of answering those questions. So even if there is a field occupied by a particular judgment, but if the public import, the president feel, I have a constitution bench judgment, I have a 7-judge judgment, I have a 3-judge judgment, I have a 2-judge judgment, which is the one which governs me. Therefore, on a question of law, if there is no authoritative pronouncement or a conclusive authority, the conclusive authority proposition related in the Bala Sahib judgment, give that reference. Therefore, there is no conclusive authority in that question. And there is a difference of views. 7, 5, 3, 2.
To get into the question as to whether the conclusive authority exists or not, then there is a problem. Even if you are asking, it's an opinion, it's all right. No, not every question also need not be answered.
I only trying to point out that when you're talking about a question of law, is there a field occupied by a judgment? And therefore, once it is occupied by a judgment, the court will not enter into 140 reference at all. Therefore, in Kaveri, followed by 2G, it says there is a decision as a state of law. I'm going to probably tell you that state of law is a very important concern for the president. I have so many judgments on my table. Which is the correct state of law? 5, 7, 9, 2, 3. Therefore, if a judgment which is a bench of 2 judges, am I bound by it? I am not trying to say that you'll overrule it as a review or an appellate jurisdiction. These are all limitations which the court will ordinarily built into Article 143, where we will not ordinarily say review them. If you actually look at a later point of time in the Tamil Nadu judgment or the Punjab judgment, we'll be easily able to convince your lordship that the line can be comfortably drawn between what on a particular set of facts the court do some conclusion. We're not talking about those conclusions in a particular set of facts. We are talking about the state of law, the view of law. The 2G judgment therefore opens up an important door for an Article 143 consideration. And I would very humbly submit, these doors probably will be kept more and more open as and when the president comes with issues of public importance.